The US Copyright Office has finally given us some clarification about the nature of copyright and AI and whether or not you can copyright anything that's been AI generated. So let's dive into the details of this clarification because it's much needed and incredibly helpful and actually a good thing for AI authors. One of the biggest things that I often see people say is that you can't copyright AI work, and now we know that that is definitively false. However, there are some caveats to that, which we will get into. So to show this off, I'm going to be looking at this article here from VentureBeat, which has a really good summary of everything. I'll link this down below. It also has a copy of the actual Copyright and Artificial Intelligence report that has come out from the US Copyright Office. Now, keep in mind, if you are in other countries outside of the US, this will not apply to you. I know in a number of countries, particularly the UK, China, New Zealand, and Japan are the ones I know off the top of my head, already grant copyright to people who have generated something with AI. And so the copyright in those countries is even stronger than it is in the US for AI generated material. However, in the US, it's always been kind of a shaky ground. The US put out a survey a while back looking at just what people were saying, and I contributed to that survey. I know a number of you did. And now we have their sort of official stance on it, at least for now. So the main thing here, as you see in their introduction, is that they clarified that some forms of AI generated content can in fact receive copyright protection, provided that a human substantially contributed or changed the content in question. So this is the crux of this whole issue. If you have made changes to the copyrighted material, you can get a copyright for that work. The report confirms that human creativity remains central to copyright law and intellectual property IP rights, even as AI tools become more widely used in artistic and commercial creation. But it should also give enterprises in particular reassurance that their brands and IP will remain protected even when they integrate distinctive products and brands into AI-generated media, such as Coca-Cola's controversial AI holiday commercial released late last year. So if you have a brand, if it's trademark or copyrighted and it's integrated with AI content, that brand, those elements still remain copyrighted. So for instance, I cannot go out and create a t-shirt with Batman on it and try to sell that thing because that would be copyright infringement, even if I used AI for it. Now, while I was reading this report, there was this interesting note here that I thought was really interesting, kind of a side note for now, but it says, the Copyright Office also said a third section of the same report will be issued in the future to address the legal implications of training AI on copyrighted material, including licensing and liability. This will be very interesting to see because we see a lot of instances right now of people suing OpenAI or other AI companies because they used copyrighted material in their training data set. And I've gone on record giving my opinion on this and why I see a lot of these lawsuits getting thrown out. But if the Copyright Office says something different, because it certainly feels like theft when it's using your work in a way where you haven't consented to it, then I could see them potentially siding with more on the side of the creator rather than the AI provider. That said, OpenAI and a bunch of these companies have a lot of legislation power inside of DC, so I wouldn't be surprised if there's something that's a little more agreeable for AI companies, but we'll just have to see. So if you are using AI to generate your drafts, what exactly qualifies as copyrightable? And the Copyright Office gave a couple of different scenarios. One, when human authored content is incorporated into the AI output. And let me just say right off the bat, this is what you should be doing anyway. If you are just letting the AI generate all the content and then you do nothing with it, you don't change it, you don't mold it to your own vision, then you shouldn't deserve to have copyright, in my opinion, because you haven't actually put in any creative work into it. I see AI as a productivity assistant for the human creator. You, the human, are still responsible for being the dominant creator in not just your work, but in your life. And if you do things the way I teach people to do on this channel and in my Story Hacker community, you will automatically qualify for this because you will have put in the work to use AI as a tool, not as a replacement for the human in its creativity. So assuming you're doing things the way I teach you to do it, this will automatically apply to you and you can file for copyright. The same goes for number two, when a human significantly modifies or arranges the AI generated material. So if you're editing the text, you're good to go. You should be fine. Additionally, if you're doing, say, a comic book and you're taking a bunch of AI generated images and arranging them in certain patterns and adding the text and all of that, that would also qualify as modifying or arranging the AI generated material. Or number three, when the human contribution is sufficiently expressive and creative. I kind of see these as is all just variations on the same thing. But they also go on to clarify that in addition, the Copyright Office makes clear that using AI in the creative process does not disqualify a work from copyright protection. AI can assist with editing and refining text, images, or music, generating drafts or preliminary ideas for human creators to shape, important clarification there, and acting as a creative assistant while the human determines the final expression. So again, if you're using AI as a creative assistant to brainstorm or to write the first draft or whatever it is, that's totally okay. And I think it's also interesting that they say using AI for editing or refining text. So I would probably venture to say, I don't know how far they would push this, but let's say you wrote a first draft and maybe your drafts are not that great, or you write very kind of a skeleton of a draft that's almost more of a fleshed out outline, and then you use AI to just make that better and edit it and improve it. That should probably still qualify as having sufficient human contribution. In fact, of course, it has sufficient human contribution, so that even though the editing pass was completely generated with AI, it was based on your draft, and so it will continue to have a significant amount of human input into it, and that should qualify for copyright, or rather it doesn't disqualify you from copyright. And so it's kind of summed up in this sentence here: as long as human authorship remains a core part of the final work, copyright protection can still apply. Now here it gets to a point where I actually disagree with the Copyright Office. However, merely providing text prompts to an AI system is not enough to establish authorship. The Copyright Office determines that prompts are generally instructions or ideas rather than expressive contributions, which are required for copyright protection. Now, I don't know what prompts they're looking at, and there certainly are some prompts out there that don't have much in the way of creativity or anything. But if you're using a tool like Novel Crafter and it's pulling all of these different things for your prompt that you have had a creative say in, like the characters, the examples of your text style, so sample chapters and things like that, and examples of the text that came before, and it's this huge complicated prompt. To me, that should be sufficient human creativity and contribution for the whole thing. Now, if you just say, like, write me 500 words about Mary having a little lamb, just something with not much creative expression in it, sure, I get what they're saying here. But the reason this bugs me is, let's take photography, for example. Do you know what qualifies as sufficient human input for you to own the copyright of an image? It is simply taking the image, pressing a button. Now, of course, you have to point the camera somewhere, and that all kind of factors into the creative expression part of photography. But really, the only thing that you have to do to be the person that owns that image is to be the person that takes the button. As a side note, be very careful when you ask strangers to take pictures for you, because potentially they actually own the copyright, not you, even though it's your camera. But that's not going to be an issue in most cases, but just so you know, that's how it works. And from my vantage point, if pushing a button is sufficient human creativity, then crafting a prompt is far more human creativity than it takes to just push a button. Now, it's a little more complicated than that, because prompts can be shared. You can give a prompt to somebody else, and in which case, yeah, they didn't really have any creative input in it. But, people do that with other things as well, where you can sell the rights to a creative asset and you can pass it off as your own, notably something like ghostwriting. So I can get the copyright for a ghostwritten piece, even though I didn't write it. So it's a complicated situation. And personally, I think if you can press a button on a camera and get copyright, then if you use a prompt, then you should be able to have copyright for that output. It's far more creative expression, I think, than in the case of photography. But that's just my opinion. It doesn't seem to be that the Copyright Office agrees with me. So if you agree with me, feel free to go in and write into the Copyright Office and let them know, because I think this is a perspective that has been lost here. These next few paragraphs clarify copyright for visual mediums like art and video. So let's read those. It says, an image generated with text-to-image AI service such as Midjourney or OpenAI's DALL-E 3 on its own could not qualify for copyright. So if it's just the image with no modification or anything like that, it does not qualify for copyright. However, if the image was used in conjunction with a human authored or human edited article such as this one, then it would seem to qualify. So for instance, I have published public domain versions of different books on Amazon. Amazon. And one of the things that Amazon asks you to do is to differentiate those public domain works. So essentially you could get copyright on that specific edition of that public domain work. And so one of the ways that they say that you can differentiate your copyright is to provide at least 10 illustrations. So if you are adding illustrations to your book, if the book has sufficient human authorship and the images are included with it, then those images can qualify for copyright because they are a part of the book, even if you made no modifications to the images whatsoever. Although I find myself, if I'm creating images to go along with my work, I usually do some form of modification, usually in the form of just a quick Photoshop or something like that to touch them up and make them a little better. So if you do something like that, they would also qualify for copyright. Similarly, for those looking to use AI video generation tools such as Runway, Pika, Luma, Hilua, Kling, OpenAI, Sora, Google Veo 2, or others, simply generating a video clip based on the description would not qualify for copyright. So again, if it's just AI output with no modification whatsoever, not qualifying for copyright. Yet, a human editing together multiple AI generated video clips into a new whole would seem to qualify. So if you take multiple AI generated video clips, you put them together into a little movie, then you can get copyright on that movie. The report also clarifies that using AI in the creative process does not disqualify a work for copyright protection. If an AI tool assists an artist, writer, musician in refining their work, the human created elements remain eligible for copyright. This aligns with historical precedents where copyright law has adapted to new technologies such as photography, film, and digital media. So there you have it. The bottom line is that if you put any kind of human authorship into your work, no matter how AI was used in the process, you qualify for copyright of that work. Just make sure you are not just taking what the AI gives you verbatim and not doing anything with it whatsoever, because that would essentially be public domain and would not qualify for copyright. But as I mentioned, if you are using my methods that I use here on this channel or that I teach in my Story Hacker membership, which you can check out below, you will not have any problem whatsoever, because you definitely will along the way be putting in the human work that needs to be done in order to write your book. So go check out the membership if that's interesting to you, and I will see you in the next video.